I've been posting quite a bit of information lately regarding the execution of wills and powers of attorney, particularly during this time when lawyers find it very difficult to meet with clients, especially elderly clients that should not be attending the office of a lawyer. In that regard, I've been very passionate throughout my career to ensure that everyone has a will. I have experienced firsthand how difficult it is for clients to have a will probated or to manage an estate without the actual will. And for that reason, I have partnered up with charities, I've done pro bono work, and I've ensured that I provided affordable legal services in this area for most of my clients that could not afford to pay regular legal fees just for having a will or powers of attorney. Okay, what is a will, first of all? A will is something that expresses the wishes of the testator with respect to their property once they die. A power of attorney is different. It is not a will. It doesn't deal at all with what happens after the person leaving the power of attorney dies. It's simply to deal with decisions during lifetime if that person does not have capacity or if that person just cannot handle their finances. So most people refer to a power of attorney as a living will. That's not a term in Ontario. The term is power of attorney, and there's two types: power of attorney for continuing property or power of attorney for personal care, which deals with healthcare decisions. Leaving that aside for now, the most important part is how do you ensure at this point during quarantine that you are able to have a will and or power of attorney. I posted a recent article regarding how to leave a will all by yourself. How do you write a will all by yourself? It's called the holograph will, and it's something that's simply handwritten by the testator and has to meet certain requirements. And I've posted that on my website, www.rsoikala.ca. You can look at that. It's completely free, and it could save you and your family a lot of trouble and a lot of expensive legal fees down the road. So I would encourage that. The holograph will I only encourage for the situation where you want to leave basically everything you have to person A and or person B, and that's it. And it's very simple. It's handwritten. You have to sign and date it, and it's a very simple process, which is not what is typically done with a proper will, which deals with taxation issues. It deals with a better understanding of exactly what happens to the estate. It deals with alternate executors, contingent plans. There's all sorts of things that you can put in a regular will, and I would never advise someone to just stick to the holograph will, but it is much better to have that at least. Now, having said all that, at this point, if you want to have a proper will, we finally have a solution. You can do this with a lawyer, and the Ministry of Attorney General has actually amended the Emergency Management and Civil Protection Act regarding virtual commissioning and execution of wills. And that is excellent, because what the Act now actually says, according to the new Ontario regulation, is that for the duration of the emergency, which is COVID-19, a requirement under the Succession Law Reform Act that a witness be present is satisfied by means of audio-visual communication. And that's both for wills and powers of attorney. And as most people know, wills require two witnesses. It is absolutely mandatory for a will to be valid to have two witnesses. That's a proper drafted will, a typed will, not the holograph will. The holograph will does not require two witnesses. So at this point, this is excellent information, because that means that you can have two witnesses that are not at your house, that are not able to come to your house or meet with you, still witness the will. The only caveat to that is the fact that one of the witnesses has to be a licensee, meaning that if you have your lawyer be a witness, that will be great, and that will meet the requirements. So you can't have two witnesses that are non-licensees. That's the only caveat, and that's both for wills and powers of attorney. And That's the most important requirement for a will to be valid on the face of it. It has to be executed properly, which the lawyer can explain to you via video or phone call, and it has to be properly witnessed, which can be done again through video. So that's excellent at this point. The second piece that most people do not understand is the fact that there has to be an affidavit of execution of will as well by one of the witnesses. So a witness has to sign an affidavit that is commissioned by a commissioner, in most cases the lawyer who drafted the will, and that's very important for a will to get probated. And the probate is very important. That's the old term, probate. The new term for that is actually certificate of appointment of estate trustee, which is basically what it sounds like. It's a certificate that allows you, as the executor of the estate, appointed through the will, or in some cases not through the will. But in this case, it says that you have the court's approval to handle the estate and to manage the estate as the executor. So it gives you the authority to go to third parties such as banks, real estate lawyers to do real estate transactions on behalf of the estate once the deceased obviously has passed away. So that is a very important requirement, that second piece. You have the witnesses, but then you also have the commissioning. But the commissioning has already been addressed. The Law Society has interpreted the commissioning rules to allow also virtual commissioning. It's a bit of a hassle because I would always recommend, in the case of wills and powers of attorneys, to have original signatures, not just simply sign online and that's it. It has to be original. So there would have to be some mailing of the documents involved, but otherwise it is excellent. It is a very good idea. So I would advise everyone to try to do that, and that's the best way to mitigate given the circumstances. Now, obviously, I would also advise my clients, once the situation is over, to come to my office and have everything properly executed in front of me and other witnesses instead of just by way of video. Why is that? This is just to protect the client, to ensure that since everyone is in the same room, there are very few arguments to be made regarding the client being pressured or someone else being in the room with them and pressuring them to sign the will, and to have a conversation with the lawyer regarding their actual wishes, but a conversation that is not via video, which is never going to be the same as in person. So there's a reason for that in-person requirement. And again, there's a reason why we have an exception right now, but I don't foresee that this will last very long. We have a lot of technological improvements these days, and there's a huge cry for changes and reform in this area, but I do not personally agree that this should be done as normal practice. For now, however, this is very good news, and I look forward to working with my clients for this. And if you have any questions, please let me know.